At Marsh McLennan, the way we have decided to staff the group that supports our board is to really focus on the legal resources that we currently have, providing the company with general legal advice. So I act as corporate secretary to the board, but I'm also the deputy general counsel for the company, overseeing a number of different functions in the department. And I have lawyers on my team who assist me with all of our 34 Act reporting, our New York Stock Exchange compliance, earnings releases, and then I also have lawyers who work on benefits and compensation matters generally for the company. So we've tapped into those resources to provide support to our board, particularly around the audit committee and the compensation committee. So I act as corporate secretary for the board, I act as secretary for our directors and governance committee, and I act as secretary to our finance committee. I then have a lawyer who supports me on the 34 Act side, who we've named the secretary of our audit committee. And the overlap there is that the audit committee is very involved in reviewing earnings releases and 34 Act filings, so she was a very logical choice to act as secretary to that committee and help support it in what it needs to do in that area. And then the lawyer on the benefits and comp side acts as secretary to our compensation committee, and she's in a very good position to help advise them on best practices, new issues, SEC rules that impact our proxy disclosure. She's actually the person who is very closely involved in drafting the CDNA for the proxy statement itself. And so between the three of us, we work very closely together and coordinate on all the issues that impact our board, which are often issues that impact the company as well. So advice and work that we're doing just in our day jobs as company lawyers translates nicely into being able to support the board on issues that impact the directors in a more direct manner. For companies that have a more dedicated corporate secretary function, where the corporate secretary is really a separate role and not someone who has a day job in the legal department, those are companies, I think, that have a very high profile. They may get numerous shareholder proposals every year, and shareholder proposals in and of themselves take several months to work through. I mean, many companies can spend half the year dealing with shareholder proposals and whether they will be included in a proxy statement, and if they are, what's the response going to be, doing shareholder engagement on the particular issue. We're fortunate at Marsh McLennan Companies that we've had no shareholder proposals in the last couple of years, and when we have had them, it's only been one or two in any given year, so it's been a much more manageable process. But for companies that are getting a lot more proposals, there are often more dedicated staffs that are just working, on board-related matters. So again, I don't think there's any right or wrong or any best practice, but it really just depends on the size and scope of the company and what works best for the particular situation.